Testimony will resume today in the Karen Reed retrial. Reed is accused of striking her boyfriend, Boston police officer John O'Keefe, with her SUV and leaving him to die in a snowstorm in 2022 outside of a house party in Canton. Reed's attorneys claim O'Keefe was killed by someone else and that she was framed. Now, in the first trial last year, the judge declared a mistrial after jurors said that they were at an impasse and deliberating any further would be futile. After the trial, several jurors said the group was unanimous in finding Reed not guilty of second-degree murder and a lesser charge. So much to discuss here, so I do want to bring in Andrea Lewis, a legal analyst, as well as a former felony prosecutor, to discuss everything here. Thank you so much for taking the time to join us and provide some expertise.
Good morning. Thank you for having me.
Of course. Well, first off, I did want to ask you, because we are talking about a retrial. The first trial ended in a mistrial. So what is the prosecution's kind of approach to this now, and how does it change from what they did during the first trial?
Sure, that's a great question. So, anytime you have a mistrial, that means the jury was just deadlocked. And they can happen for a variety of reasons. But in this case, the jury just could not render a unanimous decision. So what happens is both sides get to start fresh. They can call new witnesses. They can add new evidence. But the key difference, and it's a benefit to both parties, is that they already have the benefit of knowing how many of these witnesses would testify. They're going to know what they're going to say. Do they make a good presentation on the stand? So both sides are going into this trial with sort of a preview and some experience that they can now use to move forward on this round two.
There's no question there's been a lot of media coverage. There's been documentaries that have been watched by thousands upon thousands of people. So what measures are maybe in place here to ensure that the jury does remain unbiased amid all of that coverage?
Well, and that's really been a key issue here. And as we know from the first trial, this case, something about it has really, really just taken off, and people are extremely interested. We know from the first case, there were people protesting, and the court had to put all sorts of limitations in place outside the courthouse to prevent them interfering with the jury coming and going. So those limitations are obviously in place again. But of course, we had a lengthy jury selection in this case. I believe it was 10 days where both sides got to really question a long list of prospective jurors to make sure that they could be fair in this case and that they weren't biased.
When you talk about the fact that, and you touched on this a little already, but the fact that the first trial did end in a mistrial, how does that maybe change how the defense approaches this?
Well, one thing we know the defense is going to do is they're going to challenge the prosecution's ability even to bring all of these charges. So what the defense has already come out and said is, look, double jeopardy should apply in this case because the jurors have actually reached out and contacted some members of the defense, apparently, after the fact, and told them that they had a unanimous agreement that certain charges, they just felt like were out. And although they didn't render that formally in the court proceeding, the jurors have provided information to them that we already made our decision. And so the defense is saying, well, if they already made their decision on two of those charges, the prosecution shouldn't be able to bring those again. So far, they have not been successful with that argument in the courts. So we'll have to see how that plays out.
I have to ask, from a legal expertise perspective there, is that an example of double jeopardy? Because I'm sure you could talk to a million different legal experts who may have a different idea of whether it is or isn't.
Well, this is a bit of a tricky one, right? So we're in a gray area here to some extent, because it would be a different story if, let's say, the jurors came, and which is happened. I mean, there's nothing preventing them from telling the court that they are deadlocked on a particular charge. But in this case, it doesn't appear that happened. So in this case, from what we've heard, is that they any unanimous decision on these various counts all took place within the confines of the jury room. And that's the problem. It wasn't rendered formally. There is no formal record of it. So this is just jurors coming out after the fact and saying, hey, off the record, this is what we did in the jury room. And although there is some compelling evidence to suggest that that's what happened, I believe some produced text messages and other things. There, at this point, it just hasn't been enough to satisfy the court.
One thing that we have to touch on, of course, is the situation that played out with the lead prosecutor. I have to ask how that could maybe factor into any of this. Does it have any sort of influence over any part of this?
Sure. So we had a lot of different moving pieces and a lot of problematic, in my opinion, testimony, evidence collection, and things like that that occurred in the first case. So you mentioned prosecutor, of course, in this case, which I have found to be really interesting because this is not the norm. They actually brought in a new special prosecutor to sort of take the lead here. So you can read between the lines and think, why would they do that? What was it about the last prosecution duo that tried this case that apparently the district attorney's office felt that they could use some assistance? So that's one. But two, the issues with Michael Proctor, they just overshadowed this trial to no end. And they were really serious issues. And I can tell you from a prosecutorial standpoint, the number one thing you want to ensure is that your investigators don't have conflicts. That's just a no-brainer. You want to make sure that is not going to be any bias that weighs that's going to come into the trial. And you had all of that in the last case. In the last case, we had circumstances where there were lewd text messages from the lead investigator about the defendant herself, which shows to the jury when that's presented to them apparent extreme bias. So that didn't go well. We had problems with the evidence collection. And frankly, a lot of that could have been weeded out and prevented early on if someone within law enforcement would have said, wait a minute, you're too close to this. You're not doing a good job. We're going to back up. This is a serious case. It's involving a fellow law enforcement officer. We need to do this right. And they did not do that.
Talked about the fact that this does involve a police officer. So I have to ask, do you think this is going to set any sort of precedent for future cases that do involve law enforcement? Does that factor in any way?
I don't know that it would set a precedent. I mean, we've certainly had cases before involving law enforcement. I think what's unique about this case is the amount of law enforcement that is involved. Normally, you have them just be filling the role of investigating the case or the crime. Here, you have them as just fact witnesses. You have a law enforcement party, essentially, with all of their spouses. So these people were very familiar with one another. So there you have law enforcement that's taking the stand outside of their official capacity just to talk about what happened on this, drunken night, during this drunken gathering. So, from that perspective, it makes the case unusual. But as you see, that we already, that has created issues here or that the judge has had to deal with, such as there has been a very big media and public interest, in this case because of that. They've had to do these more lengthy jury selections. All of that is also driven by the fact that we've got so much law enforcement involved in the case, and that can help, that can be good for one side or against another, depending on what the prospective jurors' feelings are about law enforcement.
What do you think it is about this case? And you kind of just talked about it, so it popped into my mind. But what is it about this case that has so many people paying such close attention to the story itself, as well as documentaries that have been made, all of that?
It's really unusual, and it's sort of taken on a life of its own. It's this sensational interest in the case that has people, I mean, taking sides and fiercely defending them. And that's not something we see normally in a case. We don't normally have a case that generates this much public interest and this much emotion on behalf of the people who are watching it. So that's interesting. Now, why that may be, it could be the law enforcement component. It could be the fact that Karen Reed presents well. She's not someone that you would necessarily perceive to be on the outside, someone who would commit the acts that the prosecutor has accused her of. She speaks well. She has a nice presentation about her. So I think some of those play into it too, but also just the long laundry list of mistakes here. I think it really shocks people because that's not what they'd expect from law enforcement, especially on a case this serious.
For sure. And Karen Reed, do we think she's going to testify?
She seemed to indicate she was, it's funny that you mentioned that, Josh, because one of the other surprising things about this has been how much her lawyer, who by all accounts seems to be a very good lawyer, has allowed her to talk to the media. That is not the norm. You never know what your client's going to say, or as a defense attorney, they just don't know what their client's going to say to the media, and so that can be used against her. And so normally they try to keep a low profile and not present the client in that light. But here he has no problem. And just given what some statements Karen Reed made yesterday, I think that she's seriously considering doing that. So we'll have to see. Only time will tell. But it'll be interesting, certainly, if she takes the stand.
Only time will tell. Andrea,
Yeah.
thank you so much for taking the time to join us here. Anything you want to add? Anything I missed before I let you go?
No, I think that's it. I'm really looking forward to it. I mean, this trial it's full of surprises. I'm sure that this will be no different than the first. And it's really an interesting case that has a lot of legal issues that I think your viewers are going to enjoy tuning into.
All right. Thank you so much for taking the time to be here. We appreciate it.
Thanks a lot.